Morning, Your Honor. May it please the Court, my name is Kurt Mullen, and I represent the Massachusetts Insurers Insolvency Fund. The issue that's before the Court today is whether a consumer plaintiff can recover attorney's fees under 93A where it succeeds in an action against the fund for a violation of 176D39. We believe if this Court analyzes trade or commerce, which is required for an attorney's fees award, this Court will conclude that the fund does not act in trade or commerce. Whether it's, you look to the definition of that term in in Chapter 93A1, or the factors that this Court has used to determine whether it's in a business context. 93A1 requires what we ordinarily think of as trade or commerce. It requires advertising, or sale or lease or rent, or the distribution of services, but this Court has made clear that that requires either an exchange of consideration or something that takes place in a business context.
Well, I guess I'm very confused about, I appreciate that you say, well, of course, we are different from an insurance company, and Hopkins only deals with an insurance company, but both of you are covered by 176D39F, or whatever it is, and both of you are in the business of insurance, and I just don't understand why Hopkins doesn't apply here. And that therefore the second clause of 93A1 gets subsumed into the first, and attorney's fees applies.
The issue that was before the Court in Hopkins wasn't, the insurer in Hopkins wasn't arguing that it didn't act in trade or commerce. The insurer in Hopkins was an insurance company. It issued policies. It did all the things that people acting in trade or commerce do.
But it was saying, wait a minute, we're only liable under the second clause of 93A Section 9.1, right? Which is exactly what you're saying.
I think the insurer in Hopkins was making a different argument. And again, I don't think the insurer in Hopkins was making the argument it wasn't engaged in trade or commerce. I think what the insurer in Hopkins was making was the argument that an unfair or deceptive act or practice under 176D39 is not an unfair or deceptive act or practice under 93A2. And what this Court said, quite correctly, is that the unfair deceptive act or practice portion of 93A2 incorporates the unfair deceptive act or practice under 176D39. But
so we're right back there. I guess the other question I have is, this Court said in the first Wheatley case that it read the 96th Amendment as basically overruling Barrett. And if that's the case, why isn't it appropriate to read what the legislature did in 1996 as saying, for purposes of 93A, the fund is in trade or commerce?
I think it's very important to look at what the legislature did in the 1996 Amendment. When I think in the issue that was presented to the Court in Wheatley, the issue that Ms. Wheatley presented to the Court in that case was that the 1996 Amendment subjected the fund and joint underwriting associations to actions under the second prong. And that was the focus of the case that was before the Court. And the Court analyzed the argument. The fund was
Barrett, however. Barrett was a Clause 1 case.
That's correct, Your Honor. But the argument that Ms. Wheatley made to this Court was you had two decisions. You had the Barrett decision, which was a prong 1 case, saying that the fund didn't act in trade or commerce and was absolutely immune under 93A as a result. You then had the Posnick case, where this Court, in separate analyses, determined whether the medical malpractice joint underwriting association was in the business of insurance under 176D39, and then in a separate analysis determined whether it was in trade or commerce, suggesting that those are different things. And the argument that was made the last time we were here was that the 1996 Amendment subjected both the fund and joint underwriting associations established pursuant to law to 93A liability for consumer actions by subjecting them to actions under the second prong.
But it doesn't say that. It talks about both prongs, but it doesn't say this is only liable under the second prong.
But that was the only issue that was presented to the Court, Your Honor.
Okay.
I think that you still need to do the trade or commerce analysis that this Court does and look at the definition that's in 93A1 and to determine whether the activity took place in a business context. And I think it's a fact-based analysis. You look at the character of the parties, the nature of the transaction, whether it was being undertaken for a business or personal reason. And you look at you compare those factors against what it is that the fund does. The fund is a very unique entity. It doesn't act in competition with insurance companies. It doesn't issue policies. In fact, if a member insurer never became insolvent, the fund wouldn't have anything to do. But when a member insurer does become insolvent, the fund acts pursuant to 175D. It pays covered claims, it investigates them, settles and pays them, and denies all the other claims. And the money that the fund gets to pay covered claims comes from member insurers and ultimately from the public at large. And when the insolvency is closed and all the covered claims have been paid, the fund returns the money to the member insurers in the proportion that they paid. It's acting pursuant to a legislative mandate, and this Court has made very clear that even a for-profit enterprise acting in business that's doing something pursuant to a legislative mandate, much like the Feeney versus Dell decision, you're not acting in trade or commerce. And what the fund is doing, what the fund was doing in handling Ms. Wheatley's claim, it appointed defense counsel for the town, it evaluated Ms. Wheatley's claim, ultimately made an offer to settle, not within 30 days, which is where the 176D violation comes in here, but it did make an offer to settle within 90 days and paid the judgment in full. It was acting pursuant to its legislative mandate, and that's not an activity that's in trade or commerce.
So you're saying that even if a violation of 176D Section 3(9) is a violation of Section 2 of Chapter 93A, even if it is a violation, it doesn't make any difference here because you're not a Section 2 defendant. You're not in trade or commerce.
We believe that's correct. We believe this Court still needs to look, applying the factors for determining whether someone is acting in a business context, and we don't believe that the fund acts in a business context. We think when you look at the 1996 amendment and what it is that the legislature did, the backdrop of Posnick and Barrett, it did two things. It subjected the fund to 176D, and there are other specific enforcement actions, and there are other things, and giving the commissioner more specific power over the fund that the commissioner didn't have before. And number two, it subjected the fund to consumer actions under the second prong of 93A 9(1).
And what's the practical consequence of that if you're not also liable for attorney's fees or triple damages?
You're liable for actual damages, which can be substantial. You're giving the consumer...
Which in this case, I mean, apart from the Rhodes situation, they're going to be lost interest, isn't it?
There are other types of things. There are costs and frustrations of litigation. You can... emotional distress may be recoverable as actual damages. It's never been clear to me.
But here it's zero.
No, we've paid the claim for actual damages in this case. That's been settled. The only case...
The concept of 93A, which is that you get attorney's fees, shouldn't apply to these. It just doesn't make sense.
I think it does make sense, Your Honor, because that's what the statute says. The statute says you need a trade or commerce violation, whether it's attorney's fees or whether it's multiple damages.
But why go through the motions of making the violation of 176D Section 3 actionable under 93A as to the fund if it doesn't really do anything? Does 93A provide any greater relief to a plaintiff in this kind of a case against the fund than simply a violation of 176D?
176D doesn't provide a consumer plaintiff with a private right, or any plaintiff with a private right of action. So you're giving a consumer plaintiff a private right of action under 93A 9(1) that it didn't have before. That's the purpose of the 96 Amendment. And you can just read when you read the amendment, you look at 93A and 176D, that is the plain impact. And this Court has made very clear. You determine legislative intent when interpreting an unambiguous statute by simply reading the statute. And you don't think to yourself, what else could the legislature have done, or what might the legislature have done? And we cite the Sousa decision in our case. You don't import language from one statute into another.
Not importing anything. It's just reading 93A as applying to the fund.
Where the fund violates 176D 3(9). But attorney's fees, and for that reason, although multiple damages is not before the Court today, the same argument could be made with multiple damages, although there may be a very good reasons why, even if this Court were to hold attorney's fees are assessable against the fund, that multiple damages are different. But
Is there any other statute or any other cause of action that would allow a plaintiff to bring a 176D Section 3 claim against the fund other than 93A?
I believe 93A is the sole.
It's the exclusive jurisdictional statute for bringing a 176D claim against the fund.
I'm not aware of any other
Okay.
any other mechanism.
Now, I gather you're here today because you concede that whatever you settled did not include any award of attorney's fees as actual damages.
That's correct, Your Honor.
Okay, but it does seem as that if you prevail, the primary cost of a insured who is unable to resolve a case is the case is prolonged, and then they have to bring an action. It's generally attorney's fees is the single greatest expense generated by an irresponsible insurer. Wouldn't there still be attorney's fees somewhere there as actual damages arising from the insurance company's recalcitrance?
I don't know, Your Honor. The court has described costs and frustrations of litigation as being compensable. I've never looked into whether
No, it's
an
not
insured
that.
could claim that. It's never really entirely been clear to me what the scope of that is. But I think you look at what the legislature did in 1996, and that's not to say the legislature could not subject the fund to attorney's fees under 93A, but I think that they did not in the 1996 amendment. What they did is they subjected the fund to enforcement action under 176D and a private consumer cause of action under 93A.
Forget about 176D for a minute. Could the plaintiff in this case have brought just a contract action against the fund?
I think, well, the plaintiff in this case brought an action against the town. Which
Could it have brought
the plaintiff could make a claim against the fund.
in court, and so there is another way that a plaintiff can get into court and get exactly what we're talking about here in terms of damages. So why go through all the machinations about 176D and 93A? Why not just leave it to a normal contract claim?
I think in that case, it would be difficult, I think, Your Honor, because I think you'd need a judgment first. I think if there were a judgment, then the claimant could come in, and if the fund, for whatever reason, didn't pay, which wouldn't happen in the real world, but if the fund didn't pay, then the claimant could bring a reach and apply type action.
Now, the fund is an entity, and it has employees, I gather.
It does.
Okay. If the fund were to discriminate against one of its employees, and are they protected against an award for discrimination? Because that, too, would deplete the fund.
I think in that case, you'd need to look at what the statutory basis of the attorney's fees, or the proposed attorney's fees award would be.
I'm not speaking of attorney's fees. I'm just speaking in general. I mean, if you discriminate against somebody on the basis of race, I assume the fund can be sued as an employer, and there can be a judgment against the fund, and that would deplete the resources available to the fund.
I think if the fund is subject to simple tort claims, other types of claims outside of an insurance policy.
So if it's subject to simple tort claims and discrimination claims, why would unfair and deceptive conduct be the one claim that it's not subject to?
Well, it is subject to that. It's subject to a consumer right of action for single damages under 93A 9.1 because that's what the legislature said. And when the legislature wants to make that, but it's not subject for things that are assessed for trade or commerce violations, attorney's fees, and although multiple damages isn't before the court, I think a similar argument would be made by a plaintiff. And when the legislature wants to make a violation of one statute a trade or commerce violation under another statute, it puts it right in the statute it's amending. It's done that many, many times, and it's done it in pending legislation as well, filed in the last session, and I made inquiry of the House and Senate clerk for this session, but the bill text isn't available yet. Again, the question is not, could the legislature in the future make the fund liable for attorney's fees or for other things, sanctions available in trade or commerce? The issue is whether it did in 1996, and it didn't. And we believe when you look at the plain language of the statute and the protections that the legislature has given the fund in 175D, it is simply inconsistent that the legislature intended in that amendment to subject the fund to attorney's fees. Thank you.
Yes, sir.
Thank you. Good morning, Your Honors. May it please the Court, my name is Stan Wheatley, and I represent the plaintiff and the appellee, Kirsten M. Wheatley. In my brief, I described the fund's argument as the Hopkins argument because it is exactly the same argument that the defendant insurer in the Hopkins case presented and which was rejected in that case.
Except that it was Liberty Mutual?
That's correct. The defendant was
They're in
Liberty
trade or commerce. The fund is saying that, yeah, we understand that 176D is a violation of Section 2, but we're not liable under Section 2 because we are not involved in trade or commerce.
I understand that, Your Honor. That is their point of distinction.
Yeah.
That's their attempt to distinguish themselves outside of Hopkins. And I think that fails because of the 1996 amendment. The 1996 amendment represents the legislature's determination or dictation, as the phrase was used in the Wheatley case, the prior Wheatley case. The legislature dictated that for these purposes, the fund is in the business of insurance for purposes of 176D, and that makes it engaged in trade or commerce for purposes of Section 93A.
Just the same way as Liberty Mutual is what you're saying.
Correct.
In terms of the legislative history that the fund relies on, and at least there's more in the brief that I am thinking of, but what I remember from the fund's brief in terms of legislative history was references to remarks by the governor and his staff that it's really an argument that goes to the first Wheatley case, that the legislative history suggests that it was simply adding it so that the Commissioner of Insurance could enforce, but not for 93A purposes. Is there anything in the legislative history, in your view, that makes this, that says what the legislature was intending was to say that the fund was coming under 93A Section 9(1) for the second prong only?
No, Your Honor. The legislative history really was not that specific, but there are at least two things in there that I believe support our argument that the idea behind the 1996 amendment was to treat the fund the same as the for-profit insurance companies that it in effect represents in dealing with these claims. There was a letter from the then Governor's Council that described the fund as being one among others in the business of insurance. And there was a letter from, let's see, I believe it was the Department of Insurance, which basically said that, referred to the fact that the fund, Office of Consumer Affairs and Business Regulation, which referred to the fund as being fundamentally an industry group that pays claims. I believe both of those things support the notion that what the legislature was trying to do here was simply treat the fund the same as it treats any other insurance company. And that would certainly bring them under Chapter 176D, and it would also make them, at least for purposes of this type of action, make them engaged in trade or commerce for purposes of Section 2. To some extent, I think that this argument is moot because I believe that the original Wheatley case ruled that they are subject to liability under both prongs of Chapter 93A, Section 9, Sub 1.
Didn't it suggest it didn't need to reach that, or?
It addressed the two arguments separately. I believe that it held that it's liable either way, subject to liability either way. If you look at the Wheatley case begins by describing the decision in Barrett correctly as a prong 1 case, ruling that that the fund is not in trade or commerce for purposes of Section 2. And there's a footnote in Wheatley that points out that Barrett never addressed the prong 2 argument. But at pages 601 to 606, that's the core of the Wheatley decision. It explained why the 1996 amendment was intended to overrule Barrett the holding in Barrett that the fund was not in trade or commerce by dictating that the fund was in the business of insurance for purposes of 176D. And it was only after it made that, engaged in that analysis, that it went on and it said, as a second and independent reason, the fund could be liable under the second prong of 93A, Section 912, because it was a person, as that term is used under 93A. And I think probably the most important item there is that in the Wheatley decision, the court italicized the word second to emphasize that this was a new avenue or a different avenue of liability than what they had previously been discussing, which was you're in the business of insurance under 176D, and therefore you're in trade or commerce under Section 2 of 93A. And it follows that if the 1996 amendment overruled Barrett, again, Barrett is, as you pointed out, Barrett is a prong one case. And if you're overruling Barrett, by definition, you're saying you're subject to liability under prong one. And if you're subject to liability under prong one, even the fund admits that the attorney's fees provisions in Section 9, sub 4, apply. Even if you feel that Wheatley did not already rule that they're subject to liability under both prongs, clearly this case is controlled by Hopkins. The point of distinction that they've made, that clearly Liberty Mutual is in trade or commerce, but we're not, I think that's been foreclosed by the 1996 amendment and by the Wheatley decision. Basically, Hopkins is good law, Barrett is bad law. You can't use bad law to distinguish good law, is what it boils down to. The legislature has the power to do this, and it did dictate that the fund is in the business of insurance under 176D, and that's enough to make it in trade or commerce under Section 2 of 93A. And it really is just a common sense argument, too. If Chapter 93A means anything, it means multiple damages and attorney's fees. That's what people think of when they think of 93A. And it just doesn't make sense that the legislature would have taken the pains to bring the fund under the coverage of 93A, but at the same time to exempt it from its two most defining characteristics, the multiple damages and the attorney's fees.
But we don't have to reach multiple damages here anyway.
That's true, Your Honor. And certainly if they were going to do, if that was in fact their intent, which I think is very far-fetched, but if you assume that they had that far-fetched intent, certainly they wouldn't have done it silently by implication or by inference, as the fund argues here. If they were going to do such an unusual thing, they would have made it explicit when they enacted the 1996 amendment, and clearly they did not. I really have nothing else, and I'll rely on my brief unless the court has any questions that it would like me to address.
Thank you, sir.
Thank you, Your Honor.